نبدأ. الحمد لله نحمده ونستعينه ونستغفره ونعوذ بالله من شرور أنفسنا ومن سيئات أعمالنا من يهده الله فلا مضل له ومن يضلل فلا هادي له وأشهد أن لا إله إلا الله وحده لا شريك له وأشهد أن محمدا عبده ورسوله صلى الله عليه وعلى آله وأصحابه ومن تمسك بسنته إلى يوم الدين أما بعد. So as we continue this Monday lesson that we normally will discuss the book Al-Mulaqis Al-Fiqhi by Sheikh Salih Fawzan Hafidullah Ta'ala, and we're discussing matter that relates to al-usra, that relates to family life, and we have covered bab concerning al-talaq and the different types of talaq, and we have discussed matters regarding the last chapter al-raj'i, which is al-raj'a, where the husband taking back his wife, and what are the rules pertaining to those to that particular discussion. And today inshallah ta'ala we'll be discussing, as they mention here, babun fi ahkam ila. So bab fi ahkam al-ila, and we'll explain concerning, or the author Hafidullah will explain as to what is intended by this, a way that of those things that occur regarding between husband and wife, that dispute may occur, and also things may be done or said, and how to rectify those matters. Aywa.
Chapter 5, Ila Foreswearing one's wife more than 4 months. Faqihs define Ila as the potent husband swearing by Allah or one of his attributes not to have sexual intercourse with his wife forever or for a period of more than 4 months. This definition implies that the case is not regarded as Ila, which is prohibited in Islam, unless the following conditions are there.
So the author, according to in my book, he mentioned regarding Ila, and he went into discussing it by way of first the meaning, the definition, as they'll say, the definition lugatan. So the definition, according to the linguistic meaning, would mention halif. So Ila goes back to the word al-halif, where it is yamin, where the husband or a oath is taken, or a person taking an oath. And then he mentioned after then, he discussed regarding the meaning, which is a shar'an, according to the ulama, as to what is intended by the word al-ila, and what is the process, and what is involved. So you have various definitions that are given, that the author give a definition there regarding al-halaf, al-zawj, where the husband that makes an oath, yumkinuhu al-wat, the husband that is able to perform intercourse with his wife, billah aw sifatin min sifati, and he swear by Allah subhanahu wa ta'ala, or by one of the sifat of Allah subhanahu wa ta'ala, and ala tark al-wat zawjatihi, by he made this oath to Allah subhanahu wa ta'ala not to have intimacy with his wife, fi qubliha, in her private area, abadan, either forever. He made this oath not to be with his wife forever, meaning intimacy, or akthar min arba ashur, or for it to exceed over 4 months. So 4 months plus, that he take this oath by Allah subhanahu wa ta'ala that I will not have any intimacy with my wife. So this is al-ila. This is al-ila. So as we mentioned, that he mentioned that there are certain conditions that are attached to it. So you have various definitions that are given, but the Shaykh somewhat, that's of the definition that I mentioned. So halif al-zawj, where the husband take an oath, ala tark al-wat, where he abstain from having intimacy with his wife in her private area, mudda tazid ala arba ashur, and the time span that it exceed over 4 months. It must exceed 4 months. Then after Hafidullah, he mentions that there are certain conditions that are attached. So for this case to be considered to be ila, then there are certain criteria, conditions. If these conditions are fulfilled, then the matter is considered to be a case of ila. If these conditions are not fulfilled, then it is classed as something else. Aywa.
So the husband is potent. The husband swears by Allah or one of his attributes, not by divorce, emancipation, or vow. The husband swears that he will not have legal sexual intercourse with his wife. The husband swears not to have a legal sexual intercourse with his wife for more than 4 months. The wife is fit for having sexual intercourse. If all the aforementioned conditions are there, the husband is legally regarded as committing ila, and thus the rulings of ila apply to him. However, if one of these conditions is missing, the case is not considered ila.
So that's the next matter to discuss. So the first matter to discuss is what is considered to be ila, Islamically shar'an. Then the next matter are those conditions that should be in place for a case to be considered to be ila. Then he mentioned 5 conditions that ulama have mentioned. So there's 5 conditions that will set or decide whether this case is said to be ila or not. The first condition I mentioned, أن يكون الزوج يمكنه الوطء. That so you have the order may differ that as to what is, they mentioned that of the condition that the husband that is able to have intercourse with his wife, so he's capable to having intimacy with his wife. The second condition, أن يحلف بالله, that a husband also that is the one al-halif, that is the one taking the oath. So the husband taking the oath. The method by which he or the oath, it is taken by either Bismillah, with our lafz al-jalal, with the name of Allah subhanahu wa ta'ala, Allah, or with the names, one of the names of Allah subhanahu wa ta'ala, the second so, lafz al-jalal, Allah, billah, or sifa min sifatillah, one of the attributes of Allah subhanahu wa ta'ala, and third, by way of Allah subhanahu wa ta'ala's names. So the person take an oath by those, with those conditions. So you have also mentioned that la talaq, so the person wants to take this oath by thing of the makhluk, then that is not, it's an oath but it's done incorrectly. So the oath, for it to be considered to be correct, either by the name of Allah subhanahu wa ta'ala, one of the names of Allah subhanahu wa ta'ala, or of the sifat of Allah subhanahu wa ta'ala. But if it was done by way of the creation, then that is something else. That falls into something else. So, and also, at times you might find that even some ulama discuss, or some of the mashaykh have discussed concerning al-ishtiraq, at times there are certain masail fiqhiyya that overlap with matters of ahkam. So this matter is a matter of ila, it's a fiqh matter, but also it takes on or certain things of aqidah or overlap with this, which is, as I mentioned, ila is the person taking that oath. Then the third of those conditions, أن يحلف على ترك الوطء في قبل. That the third condition is that the husband must take the oath that is abstaining from having intimacy with his wife in the front area, in her vagina. So if he was to say, I'm taking an oath not to kiss my wife, not to hug my wife, then this does not count. It doesn't fall, so it has to be intimacy in her vagina. Then I mentioned the fourth, أن يحلف على ترك الوطء أكثر من 4 أشهر. Then also the fourth condition, that he has to take the oath that he will abstain from intimacy with his wife for more than 4 months. Anything below or just 4 months, it doesn't count. So it has to exceed 4 months and 1 day. If it's less than this, then it is not ila. Then they mention the fifth condition in akuna az-zawja, that goes back now to the wife. As for the wife, mimman yumkin wat'uha, that she have to be also that she's capable of having intimacy. So him having the ability, she also, and with the other conditions that are mentioned. So those concerned that al-ila that is mentioned here regarding the conditions, and as the author mentioned that all these conditions must be fulfilled for it to be classed, or this case to be considered to be ila. All these 5 conditions must be fulfilled. If one is forfeited, then it is not ila per se. Then he discussed now the third matter. Aywa.
Ila is mentioned in the Noble Quran as Allah exalted be, He says, for those who swear not to have sexual relations with their wives is a waiting time of 4 months. But if they return to normal relations, then indeed Allah is forgiving and merciful. And if they decide on divorce, then indeed Allah is hearing and knowing. Surah Al-Baqarah, chapter 22, Surah Al-Baqarah, verse 226 to 227.
Aywa.
Okay. The meaning of these 2 verses is that if the husband who swears not to have sexual intercourse with his wife for more than 4 months insists on not having sexual intercourse with her after 4 months, he is to be ordered to come back to normal sexual relation with her and expiate for his oaths. Otherwise, he must be legally ordered to divorce her if she demands divorce. The Islamic wise and just ruling removes the harm and injustice caused to women and nullifies what some men used to do in the pre-Islamic period of ignorance, the Jahiliyyah, when they used to prolong the period of Ila. Ila for more than 4 months is prohibited in Islam, as it is an oath of abandoning a marital obligation.
Aywa. And that, then the third thing, the point that the author Hafidullah he mentioned, which is the dalil. So the evidence, the proof regarding that this is something which is recognized Islamically. Then he mentioned an evidence mainly from the Quran. So the ulama mentioned that there's Quran, the evidence regarding the allowance or the permiss that Ila is something which is acknowledged. You have by way of the Quran, and he mentioned the ayah in Surah Al-Baqarah. Then also you have hadith and also ijma. So those three sources are used regarding evidence showing the permiss that the Ila being allowed, and the evidence first, which is by way of the Quran, and also the Prophet ﷺ made Ila to his wives for 1 month, or made Ila made Ila towards his wife. Then also they mention ijma, and you find the son of the ulama mention Ila regarding mention Ibn Faris of Fasi in his book Al-Ijma, which is called Al-Iqna fi Masal Ijma. So in the book Ijma or Iqna fi Masal Ijma by Al-Fasi, Ibn Fasi, that he mentioned that this is in general the ulama, they have a consensus around the general topic of Ila. Then the author, Hafidullah, he mentioned regarding concern that the option in this case, that if the husband make this oath, so the husband, for example, the husband will say in this case of Ila, they mention, Wallahi, la ujama zawjati 5 ashur. I swear, take an oath by Allah subhanahu wa ta'ala, I will not have intimacy with my wife for 5 months. Then this is Ila. So the opposite is not, I swear. So the person will say it in Arabic, so whether it is said in English or Arabic, the same ruling applies to the person. So the husband saying, I swear by Allah subhanahu wa ta'ala that I will not have any intimacy with my wife for 4 months or 6 months. Now, but have to exceed 4 months. After the time have to exceed 4 months. Our message, that's concerning Ila. So it mentioned that the proof of this is by way of Quran wa Sunnah wal Ijma. Then the author, Hafidullah, he mentioned وَهَذَا إِبْتَالَ لِمَا كَانَتْ عَلَيْهِ فِي جَاهِلِيَّةٍ. That also of the things of Ila, that was a practice that was known in the time of Jahiliyyah before Islam. So it's something that was already established before Islam. The advent of Islam, it was already established as a practice, but their form of how they did it was it would go for a year, 2 years, or up to 3. So the time period for them was much longer. So the woman was just kind of somewhat, she's there, but so the person avoid his wife, which is with Ila, is primarily regarding not having intimacy with his wife. And that's so it shows regarding that intimacy is a shared duty. Husband towards the wife and the wife to the husband. So in the case where the husband can somewhat avoid having intimacy with his wife and also swear upon this that he's not going to do this act for his wife, then it mentioned the share is considered to be a form of darar, is a form of injustice towards his wife and a pressure or harm upon his wife. Then the fourth matter the author Hafidullah he discussed, وَالْإِلَى مُحَرَّمْ فِي الْإِسْلَامِ لِأَنَّهُ يَمِينَ عَلَى تَرْكِ الْوَاجِبِ. So he mentioned that as for Ila, as for the hukum of Ila, it is said to be of is considered to be haram, which is, they say, hukum al-taklifi. So by way of hukum al-taklif, it is classed amongst those 5 ruling as being haram for the husband to do this to his wife. And also they mentioned that al-hukum al-wad'i, that some mention that hukum al-wad'i, that is still considered to be valid. Meaning, hukum al-taklifi, that what he has done to his wife is a form of harm towards her. So that is haram to harm a person by not having intimacy with her, for example, 5 months. I'm not going to have any intimacy with my wife. So that him doing that, it's haram. But what he has done, it still counts. It still counts. But he has done something which is haram. But it still counts as the ruling applies. The ruling still applies. So that's concerning that matter regarding the hukum. That is something which is haram to be done. And if it is done, then the person has to follow the rulings pertaining to Ila as to what is outlined in the Sharia. At some time in Jahiliyyah also, they use a form of either form of talaq or zihar. So in Jahiliyyah is a form of kind of something to put pressure on the wife. So they kind of say Jahiliyyah did exist in Jahiliyyah. Islam came and kind of somewhat reviewed the time span of it. Should not be it should go for 4 months, not for a year or 2 years or 3 years, as was the practice in Jahiliyyah. Aywa.
As indicated in the general meaning of the aforementioned verses, the husband is not considered to have forsworn his wife unless he can validly divorce her, whether he is a Muslim, a disbeliever, a free man, a slave, an adult, or a percipient child who will be legally ordered when he reaches puberty either to have normal sexual relation with his wife or to divorce her. The ruling on Ila is applied even if the husband made it when angry or while suffering from a curable disease. Moreover, its ruling is also applied when, if the marriage is not yet consummated, that is, the married couple have not had sexual intercourse yet. However, the husband is not considered to have forsworn having sexual intercourse his wife if he is insane or unconscious, in which cases man is unaware of what he is saying and the intention is lacking. In addition, the case is not regarded as Ila if the husband is impotent, such as castrated or a paralytic, for his oath is not the only reason for his abandonment of having sexual intercourse with his wife.
Okay, so the next matter discussed by the author, which is the fifth matter discussed concerning that yanaqad al-ila, regarding concerning those cases that it becomes of those people that it applies to them. So as for those that this rule applies to them regarding, so it in general, anyone whose talaq is valid. So anyone who can offer a valid talaq, then these rules apply to them. So it applies to the case of whether the person is a Muslim or a kafir, whether the person is a free person or non-free person, where this person is above the age of puberty. So in that case, that person, when they reach the age of puberty, then they're instructed that they have to take action at age of puberty, as they are not considered to be a full adult. And also applies, this ruling applies when the husband is said to be angry. So if he was to say these words in a time of, he claims anger, it still applies. And also in the case of illnesses, where it is an illness where he is able to recover. Then so that's concerned, so they said, based upon the umum al-ayah. So based upon the general ayah, doesn't put any type of restrictions. So anyone that is able to divorce their wife in a valid marriage, then this rule applies to their situation. So even the case, if they're married, but they have not yet consummated the marriage. So the husband got married, and he decided that I'm not going to consummate the marriage. They married this girl, they're living, for example, in a different city, and he hasn't a chance to be with her to get married, to consummate. And he can somewhat take this oath before he consummate, then the rule applies. The rule still applies, so it's not a condition for the rule to apply. Consummation have to be in place. Then I mentioned that, so as for cases where it does not apply, it does not apply in cases, they mention here too regarding majnoon, where the person said to be because of insanity, and also mughma alayh, also the person is unconscious, where the person that is faculty is not there. So the person's faculty is not there and making a conscious decision. So in that case, then the person is considered to be, in that case, not valid. In that case, it is not valid. And also in another situation that the person, because of his faculties are not there, the second of those cases that is considered to be not valid is case where the husband is not able to function. So he's not is impotent type of thing, not able to function with his wife, have intimacy with his wife. So in that case also, we said he would have forfeit one of the 5 conditions. He's not able to have intimacy. So in that case, this rule would not apply to him. Aywa.
The case is also deemed Ila if the husband swears by Allah that he will not have sexual intercourse with his wife forever, or for a period of more than 4 months, or when he stipulates something unexpected to happen before 4 months, such as the advent of Jesus Christ, the son of Mary, or the coming out of the Antichrist. Likewise, the case is considered Ila if the husband makes a condition that his wife must commit a prohibited deed or leave an obligation. For example, he may say to her, I swear by Allah that I will not have sexual intercourse with you until you have abandoned performing prayer or drinking wine, or etc. This is because he stipulates what is legally forbidden, which is similar to the case of stipulating something impossible to happen. In all the previous cases, the period of Ila must not exceed 4 months. As Allah exalted be, He says, for those who swear not to have sexual relations with their wives is a waiting time of 4 months. It is related in Sahih al-Bukhari that Ibn Umar radiallahu anhu said, when the 4 months are over, the husband must be legally ordered either to give up Ila, that is to have normal sexual relation with his wife, or to divorce her. Still, divorce is not affected unless the husband makes its pronouncement. The same ruling was related by Al-Bukhari on the authority of more than 10 companions. Sulaiman bin Yasir said,
Yes, the author Rahimah Hafidullah is now discussing regarding the mudda, which is exceed 4 months. And he mentioned regarding concerning the author of Ibn Umar, that is collected by Imam Bukhari Rahimullah, collected by Bukhari Rahimullah, and other companions who had this opinion regarding that Ila has to be 4 months or more. Anything below this, then it is not. So if the person says, I won't have intimacy for 4 months, then it is not Ila. Now I'm saying I have to exceed 4 months, I have to exceed the duration of 4 months. Aywa, so let's bring some athar of the Salaf on this matter. Aywa.
Sulaiman bin Ibn Yasir said, I was a contemporary for more than 10 of the companions of the Messenger of Allah sallallahu alaihi wasallam, and all of them were of the opinion that when the 4 months are over, the husband must be legally ordered either to give up Ila or to divorce her. This is also the opinion of the majority of Muslim scholars and the apparent meaning of the aforementioned Quranic verses. The days of menstruation are not legally included in the 4 months of Ila. If the husband has sexual intercourse with his wife after this period is over, he is considered to have returned to a normal marital life with his wife, as having sexual intercourse is a sign of returning to normal marital life. Ibn al-Mundhir said, as far as I'm concerned, all scholars unanimously agree that the returning to one's wife after Ila means having sexual intercourse with her. Thus the woman regains her marital rights from her husband.
So that mentioned فَإِنْ فَاءُوا فَإِنَّ اللَّهَ غَفُورٌ رَحِيمٌ. So mentioned fa'u in the case of, that is for a person to break this Ila, then for the husband to have intimacy with his wife. Because the oath that he took was about not having intimacy. So to break that oath, then he has to redeem that he has to have intimacy with his wife. And that's the ijma between the ulama. So an ijma between the ulama. They mention if the husband is unable due to some reason to have intimacy, then he says it in words. That I want to have intimacy, but so it will be said in words, because he may have a valid reason that he's unable to have intimacy. But the general thing is, it has to be by him having intimacy. And they mention that intimacy in the sense where the male organ that actually penetrate the female. So not just rubbing or touching, it has to enter the female. Aywa.
If the 4 months are over and the husband still refuses to have sexual intercourse with his wife, he must be forced by the judge to divorce her, provided, if it's the wife's wish, then it's because Allah exalted be, He says, and if they decide on divorce, then indeed Allah is hearing and knowing. However, if such a husband still refuses either to have normal sexual relation with his wife or to divorce her, the judge divorces her or cancels the marriage contract, as the judge is legally considered the husband's guardian in this case, so he is entitled to divorce her on behalf of the husband.
Okay, discuss the next matter regarding that when that time of reached, then either the husband has to decide that either to one, his choices are one, to break the oath, which is having relation with her, and they go back to normalcy. So that is not counted as a divorce. So the Ila is not counted as a divorce, right? So it's just for him to break it, and to renew normal relations with his wife. Then he has to have intimacy with his wife, or by way of, if he is not, then he divorce her. So the choice is intimacy or divorce your wife when that time is. And if he's somewhat insisting, he doesn't want to do both, don't want to have intimacy with her, I'm not going to divorce her. So she now said no, she's mu'allaka, she's like in a limbo, she just left there. Then it will mean a judge will now come into play and he would divorce them. So the judge, if the husband insists, so the judge will command him to either have intimacy. If he still insists he's not going to do so, then the judge, he can divorce them. And so that divorce, the discussion between ulama concerned that is this divorce considered to be divorce wahid, ithnain, or fasq. So of Ibn Taymiyyah rahimahullah, of the opinion that and also Ahmed rahimahullah riwayah, that's considered to be a divorce, only one divorce, that the judge cannot do more than one divorce, because so he cannot make it like two divorce or three divorce. It's only considered to be one divorce that have occurred between them. This is when the judge pass that judgment based upon the husband not wanting to either make a decision or one of those decisions.
She would have to command divorce for the judge to do this, right?
It's not that she have to bring the case to the judge.
It wouldn't be considered khula in this point.
No, not per se khula. So the judge in this case, some mentioned it's for the judge to make that to make the judgment call as to which way to end the marriage. But the view that is Allahu Alam, that seeing that is whatever action that is taken by the judge, it will be a talaq. It will be a talaq, only a one talaq that will be passed by the judge, not exceeding this. Because of a darar, of an harm that is being inflicted upon her, so it's to give them only one talaq and then see where things go from there. But it's not considered to be a talaq in this case. Aywa.
Okay. Faqihs apply the same ruling to those men who inexcusably and harmfully abandon having sexual intercourse with their wives for more than 4 months, even if without forswearing. The same applies in the case of zihar for a period that exceeds 4 months, after which the husband still refuses to expiate for it. These two cases have the same ruling on ila.
So I mentioned if some other things that is a mulhaq thing that are added to this. So ila is clear as to the ahkam that applies to it. But you might have other cases where they give some examples concerning zihar will be discussed soon after. But as for the cases where the husband might intentionally withhold having intimacy with his wife, but he hasn't taken oath. He's just going through the act. So he doesn't say, but he's not having intimacy with his wife, and the time is going. Then in that case, if it exceeds 4 months, then it will be considered to be ila, even though he didn't pass an oath. Because of the harm that is placed on her. And we said as for zihar, then that will be discussed also in more detail in the upcoming chapter. So it shows concerning those cases with the husband somewhat. So it shows that Islam have a balanced approach regarding matters regarding family affairs, regarding husband and wife marital affairs. That in case that the wife may have a valid reason why, she may bring her case to a body, meaning the judge, or to those in response to the judge, to look at their case if there's certain harm being done to her by way of her husband where he's not fulfilling some of her rights. So in this case, regarding intimacy is not being fulfilled, she also in those cases can raise the matter to a body, to the courts, and they can look into the matter and try to see how best to resolve it. But she has that avenue in resolving those issues that may occur with her. Aywa.
Okay. It may happen that the 4 months of ila are over while any of the spouses have a certain excuse that makes him or her unable to have sexual intercourse as a sign of returning to normal marital life. In such a case, scholars maintain that the husband must be legally ordered to return to his wife by saying something indicating returning to normal sexual relation with one another, such as saying, "I will have sexual intercourse with you once I can." This is because the main purpose of returning to one's wife is giving up the intention of harming her through ila. Such a statement made by the husband indicates his intention not to harm his wife by ila anymore. Afterwards, when he becomes able to have sexual intercourse, he has either to have sexual intercourse with his wife or to divorce her, as the excuse for not having sexual intercourse is no longer there, and Allah knows best.
Yes, with the conclusion also, Hafidullah discussed regarding that in also cases where that Ila may have occurred, but then the husband wants to have relation with his wife, but there may be things going on with one of the parties, whether by way of the wife or the husband, where they're unable to actually do the act physically because of issues or things that are there present. But so he would, by way of say this to her, say things to her, indicating his desire to have intimacy with her as soon as he's able or as soon as she's able. So that's the way regarding still breaking it in cases where both may have valid reason that they are unable to have intimacy. So as concerning this particular discussion, where again regarding the Sharia, that this practice existed in Jahiliyyah, Islam kind of somewhat put some form of rules and guidelines towards regarding Ila, where the time duration that was before was much longer. Islam kind of somewhat shortened this, and also the end, the husband has to make a decision either to keep his wife, and to indicate this he has to have intimacy, and if he choose not to, then either to divorce her. If he choose neither of both, then for her she can raise the matter to the judge, and then they can look into the matter and they will rule accordingly. So that inshallah ta'ala we have ended this chapter, and the next chapter regarding zihar, we will discuss that inshallah ta'ala in next week's lesson. So we'll end here bi'idhnillahi ta'ala wa billahi ta'ala tawfiq wa hadil as-sabil wal akhir alhamdulillah alamin. Stop recording? Okay.
What reasons would there be for Ila? And is there valid reasons? Is it just for punishment or something like that?
Yeah, sometimes you might find a case like that, either concerned that it's either a case where the husband wants to punish his wife. You understand? So a form of punishment, he decided no intimacy, or a case that he just sometimes maybe a case where he's trying to end the relationship. And doesn't know, you understand, doesn't want to be, or want to put pressure on her to end the relationship by way of khula. You understand? So you don't want to end it, so you want her to, you understand? So it could be, you understand, so that is being considered malicious.